Good afternoon, Your Honors. This is the case number ICTY 9725A. The Prosecutor versus Milorad Krnojelac.
Bien, est-ce que les parties...
Very well. Could the parties please introduce themselves? Could we have the appearances for the prosecution first of all, please?
Your Honors, my name is Anthony Carmona. I appear on behalf of the prosecutor. Appearing with me is Ms. Noel Rashid and Ms. Helen Brady. Our case manager, in fact, is Ms. Lourdes Galicia. As a courtesy, I should indicate to you that our lead counsel, Mr. Christopher Staker, in fact, has since left the office of the prosecutor. Thank you very much.
Bien. Merci.
Very well, thank you. Could we have the appearances for the defense, please? Your Honors, good day. My name is Mihailo Bakrac, and I'm accompanied by my colleague, Miroslav Vasic. We represent the accused, Mr. Krnojelac.
Bien, merci. À présent,
Very well, thank you. Can the interpreters hear me now?
pas de problème?
No problems?
J'entends pas.
I don't hear them. There are no problems for the booths. Very well, thank you. The appeals, the Krnojelac appeals judgment is holding its public hearing today to pronounce its judgment on the appeal in the case of the prosecutor versus Milorad Krnojelac. On the 12th of April 2002, Milorad Krnojelac filed a notice of appeal against the judgment rendered on the 15th of March 2002 by Trial Chamber 2, composed of Judges David Hunt, Florence Mumba, and Daqun, sentencing Krnojelac to a single sentence of 7.5 years in prison. The trial chamber found Krnojelac guilty of persecution as a crime against humanity, based upon imprisonment, living conditions, and beatings, both for his individual responsibility and as a superior. For inhumane acts as a crime against humanity based upon beatings as a superior. Cruel treatment as a violation of the laws or customs of war based upon beatings as a superior. And cruel treatment as a violation of the laws or customs of war based upon living conditions for his individual responsibility. Milorad Krnojelac was acquitted of the following counts. Count 2, torture as a violation of the laws or customs of war. Count 4, torture as a crime against humanity. Count 8, murder as a violation of the laws or customs of war. Count 10, murder as a crime against humanity. Count 11, imprisonment as a crime against humanity. Count 13, inhumane acts as a crime against humanity based upon living conditions. On the 15th of April 2002, the prosecutor also appealed the judgment, and it should be noted that the two parties appealed the sentence. The appeals chamber will render its finding on each appeal presented under the understanding that this summary of the appeals judgment is in no way the authoritative version. In this respect, I would like to inform you that the written version will be postponed. It will be provided a few hours later. I would just like to point out that one of the parties had filed a request, a very late request, and this has resulted in the fact that the document will be provided to you at a later date, but towards the end of the day, I hope. The appeal of Milorad Krnojelac. Aside from his ground of appeal relating to the sentence, Milorad Krnojelac presented 5 grounds of appeal. Reference must first be made to the prosecutor's submission with regard to various factual issues that the errors alleged by the defense do not satisfy the standard of review on appeal provided for in the case law of the tribunal. The appeals chamber recalls that, as opposed to the procedures in force in certain national systems, the appeals procedure provided for under Article 25 of the Statute of the ICTY is corrective by nature and is not therefore an occasion for re-examination de novo. This system of appeal has consequences on the nature of the arguments that a party may legitimately present on appeal and on the general burden of proof which it must satisfy in order for the appeals chamber to intervene. With particular regard to the alleged errors of fact, a party alleging this type of error in support of an appeal against a conviction must provide proof, firstly, that the error was committed, and secondly, that this resulted in a miscarriage of justice. The appeals chamber regularly recalled that it does not amend lightly factual findings reached by the trial chamber. The appeals chamber emphasizes that its established case law sets out that if a party is not in a position to explain how an alleged error invalidates the decision, it must, as a general rule, refrain from appealing on that point. The appeals chamber considers that this principle applies to allegations of both legal and factual errors. Consequently, when a party's arguments have no chance of securing a reversal or review of the impugned decision, the appeals chamber may reject them as unlawful grounds from the outset and does not have to examine them on the merits. The appeals chamber holds that almost all of the grounds of appeal of the defense, which raise factual errors as such, are, in this case, unlawful. Generally, it emerges from the defense appeal brief that, with the exception of one ground of appeal and the ground relating to the sentence, it put forwards no argument demonstrating the unreasonable nature of the trial chamber's findings. It is, in fact, impossible for the appeals chamber to identify the error allegedly committed by the trial chamber. It appears that the defense only challenges the trial chamber's findings and suggests an alternative assessment of the evidence. However, this simple challenging of the judgment is no way sufficiently demonstrates the erroneous nature of the trial chamber's findings. By not indicating how the trial chamber's assessment of the evidence cited is unreasonable and erroneous, the defense is not assuming the burden of proof associated with allegations of errors of fact. The appeals chamber examined the admissibility of each ground of appeal alleging errors of fact and found that the first, third, and fourth grounds of appeal of the defense were unlawful in view of the aforementioned standard of review. The defense satisfied the burden of proof for the fifth ground of appeal, which alleged an error of fact. The appeals chamber therefore examined the merits of the arguments relating to this ground. The second ground of appeal of the defense, alleging an error by the trial chamber on a point of law, was also examined by the appeals chamber. Krnojelac's second ground of appeal, which concerned aiding and abetting persecution, imprisonment, and living conditions. This ground of appeal is divided into three main subgrounds. First subground, Krnojelac's acts or omissions and their significance for the commission of the crime of persecution on the basis of imprisonment and living conditions. Krnojelac states that the trial chamber committed an error of law when it found him guilty of aiding and abetting persecution on the basis of imprisonment of non-Serb civilian detainees and living conditions imposed on them without clarifying how he had contributed significantly to the commission of these crimes by their principal perpetrators. The appeals chamber examined the substance of this subground, firstly with regard to imprisonment and secondly with regard to the living conditions. The appeals chamber considered this subground as a challenge to the reasoning used for the actus reus of aiding and abetting. It recalled as an introductory point that the aider and abetter must, by his acts or omissions, have provided the principal perpetrator with practical assistance, encouragement, or moral support, which had a substantial effect on the commission of the crime. With regard to imprisonment, the appeals chamber states that a reading of the judgment contradicts Krnojelac's assertion that the trial chamber did not specify acts or omissions by which he provided the principal perpetrators of the crime of persecution, based on the imprisonment of the non-Serb civilian detainees, practical insistence, with encouragement or moral support, which had a substantial effect on the commission of the crime by those perpetrators. With regard to the living conditions, the appeals chamber stated that, contrary to Krnojelac's assertions, the trial chamber did characterize the omission underpinning his conviction as aider and abettor to those who inflicted inhumane living conditions on the non-Serb detainees. Second subground, Krnojelac's knowledge that through his acts or omissions he was contributing in a significant way to the underlying crimes committed by the principal perpetrators, persecution on the basis of imprisonment and living conditions, and Krnojelac's knowledge of the discriminatory intent of the perpetrators. Contrary to the previous subground, this subground concerns the mens rea and not the actus reus of aiding and abetting persecution. Despite the allegations put forward by the defense, the appeals chamber considered that this subground alleged, in substance, an error of fact rather than an error of law. The appeals chamber also examined, firstly, Krnojelac's allegations relating to imprisonment, and secondly, those relating to the living conditions. With regard to the two allegations, the appeals chamber indicated that Krnojelac did not demonstrate how the factual findings in question were unreasonable. The appeals chamber thus rejects the first claim of the second subground. Third subground, the mens rea of the aider and abettor to an act of persecution. This error of law alleged by Krnojelac raises the question of knowing whether, in establishing the mens rea of the aider and abettor to persecution, it suffices to demonstrate that the person concerned voluntarily provided the principal perpetrator with his practical insistence or encouragement, knowing that the principal had discriminatory intent, or whether it is also necessary to demonstrate that the aider and abettor was also driven by such intent. The appeals chamber holds that the aider and abettor to persecution, a crime with special intent, must not only have knowledge of the crime whose perpetration he is facilitating, but must also be aware of the discriminatory intent of the perpetrators of the crime. He must not necessarily share that intent, but must be aware of the discriminatory context in which the crime is to be committed, and know that his support or encouragement is to have a substantial effect on its commission. The appeals chamber points out that this is the very criterion applied by the trial chamber in the case in point, in paragraphs 489 and 490 of the judgment. Consequently, the second ground of appeal of the defense has been rejected. I will now turn to the Krnojelac's fifth ground of appeal, which concerns superior responsibility for beatings inflicted on detainees. Krnojelac maintains that the trial chamber erred in finding him guilty as superior, pursuant to Article 7.3 of the Statute, of inhumane acts and cruel treatment on the basis of beatings. He asserts that the trial chamber erroneously concluded that he was aware that beatings were being inflicted on the detainees. Krnojelac challenges the three main pieces of evidence on which the trial chamber relied in determining whether he had the requisite knowledge. The appeals chamber did not consider the arguments presented by Krnojelac in support of this ground of appeal to be convincing. It therefore rejected the arguments relating to this ground of appeal as lacking in merit. The fifth ground of appeal is therefore rejected.
We shall now address the appeal of the prosecutor. The prosecutor presented 7 grounds of appeal. The appeals chamber will set out its findings relating to each ground of appeal. First ground of appeal, the trial chamber erred in law in defining the responsibility arising from participation in a joint criminal enterprise and in applying this definition to the facts of the case. According to the prosecutor, had the definition of joint criminal enterprise been applied correctly, Krnojelac would have been found guilty as co-perpetrator and not as aider and abettor to the crimes of persecution, imprisonment and inhumane acts and cruel treatment, living conditions, on counts 1 and 15 of the indictment. The appeals chamber considers that in establishing the intent to participate in a systemic joint criminal enterprise, the trial chamber, by requiring evidence of an agreement on the commission of each of the crimes with the joint enterprise, went beyond the criterion set by the appeals chamber in the Tadic case. Since the trial chamber's findings showed that the system in place at the KP Dom was meant to subject the non-Serb detainees to inhumane living conditions and ill treatment on discriminatory grounds, the trial chamber had to examine whether or not Krnojelac had knowledge of the system and subscribed thereto, without it needing to be established that he had entered with the guards and soldiers, the principal perpetrators, into an agreement to commit the crimes implicit in the system. The appeals chamber holds that the scope of the alleged error depends on the issue of whether applying the criterion set by the Tadic appeals judgment, that is, determining intent on the basis of knowledge of the system and adherence thereto, rather than the trial chamber's criterion which requires the aforementioned agreement, would have entailed Krnojelac's liability as co-perpetrator and not as a simple aider and abettor. If this is the case, consideration should be given to whether the error in question invalidates the judgment. By applying the appropriate criterion to the facts of the case, and given the factual findings of the trial chamber relating to the living conditions constituting inhumane acts, the beatings, torture, and imprisonment, the appeals chamber concluded that the error committed by the trial chamber was an error which invalidated the verdict, insofar as the application of that criterion should have led the trial chamber to find Krnojelac guilty as a co-perpetrator. The appeals chamber considers that the error of law committed by the trial chamber was such as to invalidate the judgment. Consequently, the appeals chamber finds Krnojelac guilty as co-perpetrator under counts 1 and 5 for the crimes of persecution, imprisonment and inhumane acts, and cruel treatment on the basis of living conditions imposed, and this as guilty as co-perpetrator. Moreover, the prosecutor criticizes the trial chamber for partitioning the forms of conduct, which she believed constituted part of a system, according to the different categories of crimes underpinning the persecution charge. The appeals chamber holds, firstly, that all the and referring to the concentration camps of the Second World War, the appeals chamber holds, firstly, that although the second category could be defined by the Tadic appeals judgment, hereinafter systemic case, clearly draws on the Second World War extermination concentration camp cases. It can be applied to other cases, in particular to the serious violations of international humanitarian law committed in the territory of the former Yugoslavia since 1991. Even though the perpetrators of the acts tried in the aforementioned concentration camps cases were mostly members of criminal organizations, the Tadic case law did not hold that an individual had to belong to such an organization to be deemed a member of the joint criminal enterprise. According to the Tadic's appeals judgment, what characterizes this category of cases, a variant of the first, is the existence of an organized system to achieve a joint criminal purpose. For the requisite intent to be constituted, the accused must have had personal knowledge of the system in question, whether proved by express testimony or inferred from the accused's position of authority, and the intent to further that concerted system. The prosecutor could then rely on this form of joint criminal enterprise. The appeals chamber recalls that it is for the prosecutor to determine the legal theory which she believes most likely demonstrates that the facts she intends to submit for the trial chamber's assessment make it possible to establish the responsibility of the person being prosecuted. To this end, the prosecutor may additionally or alternatively allege one or more legal theories, under the condition that she does so clearly, soon enough, and in any event in time, to put the accused on notice of what precisely he is charged with, and in time to allow the defense to organize its case accordingly. The appeals chamber considers well-founded the challenge raised by the prosecutor to the partitioning made by the trial chamber. By replacing the trial chamber's approach in its context, the appeals chamber notes that the trial chamber clearly followed the approach taken in the indictment, since for each aspect of the common purpose pleaded by the prosecutor, it sought to determine whether Krnojelac shared the intent of the principal offenders. According to the appeals chamber, such an approach corresponds more closely to the first category of joint criminal enterprise than the second, but does not constitute an error of law, insofar as the prosecutor did not include in the theory of systemic joint criminal enterprise a better suited definition of the common purpose. Therefore, the appeals chamber does not discern any error in the approach followed by the trial chamber. The issue of what approach seems the most appropriate for determining whether a participant in a systemic joint criminal enterprise, be it as a co-perpetrator or an aider and abettor, may be responsible for crimes committed by the principal offenders in a context such as that of the KP Dom, is considered one of general importance to the tribunal's case law, and the appeals chamber therefore examined it, limiting itself to the acts charged as persecution. The appeals chamber finds that the most appropriate approach for the prosecutor in this case would have been to limit the definition of the common purpose within the KP-DOM system to the commission of those crimes which, having regard for the context and evidence tendered, could be considered, beyond all reasonable doubt, common to all the perpetrators. As an alternative, at least, the prosecutor should thus have specified the form under which she thought the accused's responsibility could be entailed for the crimes which were not clearly part of the joint purpose of the system as set out. According to the appeals chamber, the following approach could have been envisaged. As to the alleged crimes, such as the killings, which, though committed at the KP-DOM, clearly surpassed the system's common purpose, liability may be imputed to a participant in the system for crimes of this kind committed by another participant if it was foreseeable that such a crime was likely to be committed by one participant or the other, and the former willingly took the risk or was indifferent to it. The appeals chamber notes that such was the prosecutor's case for the killings in her pre-trial brief. With regard to the alleged crimes, which, although bringing together several co-perpetrators within the KP-DOM, do not appear to constitute, beyond all reasonable doubt, a purpose common to all the participants in the system, they should be addressed without recourse to the notion of system, as part of a joint criminal enterprise of the first category. The appeals chamber holds that the alleged crime of forced labor must be dealt with in this way. A person who had participated in its commission might be considered as a co-perpetrator in a joint criminal enterprise, which has as an objective the commission of those crimes in question, provided that the person concerned shares the joint intent of the principal perpetrators. Alternatively, the person concerned might be considered an aider and abettor of the crime if he simply had knowledge of the intent of its perpetrators and provided them with assistance which had a substantial effect on the commission of the crime. As far as deportation is concerned, a distinction should be made into the various alleged crimes which fit into a broader plan, such as imprisonment and deportation, on the basis of whether they form part of the common purpose of all the participants in the system and other perpetrators outside it or form part of a common purpose shared by only some of the participants in the system and the outsiders. In the first instance to which the crime of imprisonment is related, the system notion can be applied to all of the participants. However, the distinctive nature of the crime stems from the fact that some of the principal offenders are persons outside of the system in place at the camp. That is, with respect to imprisonment, certain civilian and/or military authority that ordered the arbitrary arrest and detention at the KP Dom. In the second instance, to which the crime of deportation or transfer of some of the non-Serbs detainees is related, the crimes in question should be considered without applying the system notion. A person who participated in their commission might be considered a co-perpetrator in a joint criminal enterprise, the purport of which is the commission of the crimes in question, provided that the person concerned shares the joint purpose of the principal perpetrators. Alternatively, the person concerned might be considered an aider and abettor to the crimes if they simply had knowledge of the intent of the principal perpetrators and provided them with assistance which had a substantial effect on the commission of the crimes. We shall now address the second ground of appeal. The prosecutor maintains that the trial chamber erred in law when it found that the accused could not be held liable under the third form of the joint criminal enterprise. The trial chamber erred in law when it required that the indictment refer to an extended form of the joint criminal enterprise. The prosecutor maintains that the trial chamber erred in law when it found that the accused could not be held liable under the same form of joint criminal enterprise referred to in the Tadic appeals judgment with respect to any of the crimes alleged, unless an extended joint criminal enterprise was expressly pleaded in the judgment. The prosecutor does not request that the trial judgment be reversed or revised on this point. She raises this ground of appeal because of its general significance to the case law of the tribunal. The appeals chamber notes that, in its decision on the form of the second amended indictment, the trial chamber, which was in particular seized of a complaint about the lack of precision in paragraph 5.2 of the indictment in question, indicated that in that indictment the prosecutor presented for the first time the theory of common purpose and responded to the question of what exactly was covered by this theory. In so doing, the trial chamber set out the three categories of cases referred to in the Tadic appeal judgment. In the light of this decision, had she considered that the trial chamber had misinterpreted her intentions on this point, it would have been for the prosecutor to remove any ambiguity in this respect, either by asking the trial chamber to reconsider its decision or by requesting leave to amend the indictment. Should the prosecutor have considered basing her argument on an extended concept of joint criminal enterprise only after the said decision, it would have been for her to request leave to amend the indictment. The appeals chamber notes that the trial chamber judgment shows that the chamber concluded as it did precisely because the prosecutor did not amend the indictment after the trial chamber held without ambiguity that the second amended indictment did not consider an extended form of joint criminal enterprise. In view of these circumstances, the trial chamber considered that in the exercise of its discretion, it would be unfair to the accused to allow the prosecutor to rely on an extended concept of joint criminal enterprise in order to establish his responsibility. It must be noted that these circumstances give rise to a certain amount of uncertainty for the defense with regard to the prosecution case. Consequently, although Krnojelac closing brief shows that he did consider the three forms of joint criminal enterprise set out in the Tadic's appeal judgment before concluding that he had not taken part in a joint criminal enterprise, the appeal chamber considers that, in view of the persisting ambiguity about what exactly was the prosecutor's argument, the trial chamber was well-founded in refusing, in all fairness, to consider an extended form of responsibility against Krnojelac. This ground of appeal is therefore rejected. Now let's look into the third ground of appeal. The trial chamber erred, in fact, by concluding that Krnojelac did not know, or did not have reason to know, that his subordinates were torturing the detainees and consequently could not be held responsible pursuant to Article 7.3 of the statute. The appeals chamber recall the relevant facts accepted by the trial chamber. These facts related to A. The context of the commission of the beatings and the widespread nature of their commission. B. Krnojelac authority over his subordinates as prison warden. And C. The frequency of the interrogations and punishment inflicted on the detainees. The Appeals Chamber holds that both the external context, that is, the circumstances in which the detention center was set up, and the internal context, i.e. the operation of the center, in particular the widespread nature of the beatings and the frequency of the interrogations, together with the fact that Krnojelac witnessed the beatings inflicted on Zekovic, apparently inflicted for the prohibited purpose of punishing him from his escape attempt, that subsequent to this event at least one other detainee, witness FWS 73, was victim to acts of torture, and that the trial chamber did not accept Krnojelac's declaration that he was not aware of any punishment inflicted on account of Zekovic's escape, mean that no reasonable trier of fact could fail to conclude that Krnojelac had reason to know that some of the acts were or could have been committed for one of the purposes prohibited by the rules of law relating to torture. Krnojelac had a certain amount of general information alerting him to possible acts constituting torture by his subordinates. Thus, he incurs liability pursuant to Article 7.3 of the statute. It cannot be overly stressed that when superior responsibility is at issue, an accused is not implicated for the crimes of his subordinates, but for failure to carry out his duty as superior, that is, to exercise control. There is no doubt that, given the information he possessed, Krnojelac was in a position to exercise such control, that is, to investigate the possible commission of acts of torture. The trial chamber considers, moreover, that, as regards beatings, he had the authority to prevent the crimes or punish the perpetrators. Considering that no reasonable trier of fact could have arrived at the same factual findings as the trial chamber, the appeals chamber holds that the trial chamber committed an error of fact. As regards whether this error resulted in a miscarriage of justice, the appeals chamber adopts the findings of the ICTY appeals chamber in the Rutaganda case and considers that when the accused was erroneously acquitted by the trial chamber, the latter failed in its duty by not identifying all the requisite legal implication of the evidence presented.